Good morning, everyone. Can you hear me? Welcome to the first session, second panel of this important international conference. I'm Rachele Hassan, postdoctoral researcher in Roman law and Latin literature here at Tel Aviv University. And first of all, I would like to warmly thank Dr. David Schur and all the organizers for having given me the honor of chairing this panel. Our topic is Roman law and transition, an interesting field of research for the legal historian, as I'm sure we shall see in the papers given today. But as time is limited, I don't want to take any more away from the speakers, and so I'm pleased to present our distinguished members. Dr. Dmitry Poldnikov from the Higher School of Economics, Moscow, Professor Silvia Schiavo from the University of Ferrara, Martin Ribari from the University of Manchester, and Oliver Unger from the Max Planck Institute of Hamburg. Let me note that at the end of the presentation, we will welcome questions from the audience. And now it's my privilege to present our first speaker, Dmitry Poldnikov. And he graduated from Moscow State of University with a thesis on the contractual doctrines of the Glossator of Bologna. He's currently a researcher there and lecturer at the Higher School of Economics. His research includes doctrinal history of contract law in the Jus Commune and history of jurisprudence. Dr. Poldnikov will talk about Roman law, academic debates, and the three transitions of private law in Europe. The floor is yours.
Thank you, Rachele. Dear friends. Dear friends, I'm so pleased to be honored with opening this floor. And this is the primary way we've been distinguished. I don't know what to say about this nice presentation of Rachele, that we are already distinguished scholars. Facing with this challenge of opening the floor, I could do no other than thinking about some framework for discussing the role of Roman law through the centuries. As Rachele mentioned, I give lectures at High School of Economics, and those lectures are on general legal history, or foreign legal history as we call it. And it sometimes, it covers a vast range of centuries from the ancient world until the 20th century. And it's hard to explain our first-year students, and it's not the first-year students. It's hard to explain them what are the bridges between the centuries. So my presentation will be focused on one of those bridges, which can link not only the centuries of European history or Western legal history, but also to connect that history with Russian legal history and to change the perspective or to challenge the Western European perspective on European legal history. The key terms for this presentation is Roman law, academic debate, and the transition of private law. As we all know, legal history is mostly about change, and change is almost it can be perceived in every century of legal history, and we still need some theory of change. The historians, legal historians, still need some theory of change. That theory of change can be a metaphor, as it was thought of in the Middle Ages or even from the early modern period. The metaphor of torch of light. That torch of light was associated with the study of Roman law, which was passed on according to Guillaume Baudet, the first humanist, legal humanist in France. It was passed on from the Italians to France. then Germans would argue that that torch was taken from France to Germany, and Franz Werker would, and John Austin would comment on the Empire of Light that he discovered when he came from the country of common law, from England to Germany, and discovered that it was more structured and organized. And the same image of the light associated with Roman law or with legal science was also quite popular with Russian scholars in the second half of the 19th century. So my point here is that to explain the development and transition in history throughout centuries is to focus on some catalysts behind this history, and those are exactly the key terms of my presentation. That is Roman law, the academic debate and the academia, and the debates itself, themselves about the Roman law. I won't, as the time is limited, I won't take too much of your time of sharing my thoughts about the first two transitions, the emergence of Roman law studies in Western Europe, or re-emergence of that studies from the 12th century on, or the transition from pan-European or jus commune science to national-based science in the age of humanist jurisprudence and rediscovery of legal history. I would rather add more information about the transition from Eastern European to scientified European transition in Russia in the second half of the 19th century. It was also based on the reform of the institutions responsible for the academic debate in legal matters. The necessity for initiating that kind of debate was caused by the series of legal reforms in the early 1860s. Those reforms introduced open debate on criminal and legal issues at court. The courts were obliged to reason their decisions, unlike the previously established practice. And those decisions also opened the way for interpreting the laws instead of waiting for clarifications from higher authorities. So those of you who are familiar with the major components I've mentioned would say that they are very different. If we talk about Roman law through all these centuries, it was just a shell which had different content. If we talk about Roman law in the medieval period, it was the law of the empire or the law par excellence. There was no other general law in Europe. If we talk about the renaissance of historical knowledge and the foundations of the historical jurisprudence, historically based jurisprudence, Roman law became more like common wisdom and ratio scripta in that sense. At least the research of Guzman Brito in his monography of 1981 indicates that the term ratio scripta goes back to the debate of French scholars, not to the Italian ones, in the late medieval period and early modernity. And when Russian scholars came to the idea of Roman law, they found that it was by then the theory of private law, or theory of the basis of the theory of law. So the very different understanding of law. The same is true for the academia, the second staple or the second catalyst for the transitions. Academics in the medieval period conducted different types of debates. They were primarily focused on the exegesis of the Roman texts or the other authoritative texts of law. The academics of the early modernity shifted their attention to reconciling the national laws and customs with the learned law, and the debates of the Russian scholars of the second half of the 19th century focused their attention on searching for the general principles of jurisprudence, which are partly reflected in the Roman law and the legal theory developed in German-speaking universities in the 19th century. The most specific, the difference in the debates is most obvious when you talk about the specialities of Roman law, the technicalities of Roman law, as the example of the formal contract of the stipulation. For the glossators and commentators, this debate on the stipulation was a debate about the meaning of this contract and the exceptions from this contract if they wanted to reconcile it with the existing practice. For the founders of the national jurisprudence in France or in Spain in the 16th century and on, the debate on the stipulation was rather the refusal of the formalities which were not the reflection of the general wisdom, which is generally in the Roman law. And the idea of stipulation was almost absent from the debate of the Russian scholars of the 19th century, because the idea of informal contract conclusion was essential for them. Can we come up with some kind of classification and theory behind this change and transition from one understanding of Roman law to another? I believe that yes, especially if we reject the rigid schemes and classifications of the 19th century style and move on to a more flexible taxonomy of the postmodern comparative study, comparative contemporary study, and legal historical study. And I'd like to build on the proposal of Ugo Mattei, a prominent Italian comparatist of our days, who proposed the idea of patterns of law, 3 patterns of law, or 3 models of law. He classified the model of law which is predominant in Western Europe as professional law, while the law which is predominant in Eastern Europe and Russia in particular as political law, on the basis that professionals play the leading role in the West and politicians play the leading role in the East. But when we talk about that period of the first transition in Russian history, I would argue that Russia had more in common with the Western professional legal tradition, mostly because of the role of the institutional role of the university, of the academia, and the debate. I won't go into details of the academic curriculum. I would just briefly state that Roman law played an essential role in that curriculum as it was reformed since 1863. And there were 3 subjects on Roman law, starting from the history of Roman law, then the dogmatics of Roman law, the theory of civil law, and the history of Byzantine law. It was even augmented with the general course on the Encyclopedia of Law, which presented the overall wisdom of legal theory. The focus was shifted from the study of laws or statutes to the study of law as jurisprudence. And the second point, which correlates connects Russian legal history of the 19th century with the Western European one, is the very essence or the role of the academia, its proactive position. That's where I would like to conclude. And proactive means that the academics focus on some point of partition, some point of departure. In many cases, this is the point of Roman law. But they look for the challenges and issues and they want to rethink and recreate this partition point, and they want to move further from that starting point. That proactive position, which is still which is still it takes credit for the active role of the academia in the present day German legal science or Russian legal science, secured the long-standing academic mentality, which was the essence, it was the pledge for the Russian legal scholars to return to this academic and romanistically founded legal science after the transition from Soviet law to post-Soviet law in Russia. So the tentative taxonomy for this transition, for these many transitions from Roman law to national law, is that the academics played the key role. They took the proactive position, and they looked for the potential problems, and they looked for the solutions for those problems. But the solutions differed from the period they were active. And with that, I would conclude my my thoughts about those transitions. I would welcome your questions and some thoughts about it. Thank you.